Welcome back. I hope everyone had an enjoyable lunch, and I also hope, in the spirit of what we heard this morning, that everyone took the opportunity to use the stairs, walk around the neighborhood, take advantage of this wonderful spring day. Let's hope this time it actually lasts. Um, so this morning we talked a lot about wellness programs, their design, what some of the outcomes might be. This afternoon we're going to talk about some of the other policy and ethical issues that arise in the context of wellness programs. And for our first two speakers this afternoon, we're going to talk about the question of whether or not wellness programs pose the risk of encouraging workplace discrimination. If employers are seeking to save money by having a healthier workforce, certainly one thing they can do is encourage their employees to be healthier. But perhaps another thing they could do would be to hire healthier employees. And this is something that the federal government has been paying attention to. I believe there is there is a proposed rule from the Equal Employment Opportunity Commission that will be finalized in the coming weeks, I expect. So to talk about the potential risks and issues related to potential workplace discrimination in the context of wellness, we have two folks that really are ideal to address this subject. First, we will hear from Professor Sam Bagenstos, who is the Frank Miller Professor of Law at the University of Michigan School of Law. He previously has served as the Principal Deputy Assistant Attorney General for Civil Rights in the Justice Department. And then we will hear from Christopher Kuczynski, who is Assistant Legal Counsel and Director of the ADA GINA Policy Division at the U.S. Equal Employment Opportunity Commission. And he previously served in both the White House Domestic Policy Council as well as in the Civil Rights Division of the Department of Justice as well. And I should note that some of his colleagues from the EEOC have set up a table outside that has information on various issues that the EEOC works on and has EEOC swag. So there are pens, stickies, and emery boards with the EEOC logo. So
We can't even
don't
get
make
that
them
at the
carry
office.
don't make them carry all of that back to their office. But also, please, during the break, they have information they can provide as well. You didn't come here to listen to me, so I'm going to turn it over to Sam to lead off this discussion of discrimination in the context of wellness programs.
So thank you very much. I'm really happy to be here. This is a terrific group of people on this panel at the moment, but this entire conference. I got in sort of toward the end of the morning session. It seemed like a very positive session with respect to people's views of wellness programs. So I'm hoping that changes now, and I can make that happen. So I wrote my working title, and it does say here is Bagenstos' polemic against wellness. I'll try to be a little less polemical, but at least give you a sense of what are the views. I'm going to spend most of my time in the talk talking about disability discrimination issues, and particularly issues regarding the application of the ADA to workplace wellness programs. But in the paper that I will provide, I have lots. As George Costanza's dad said at Festivus, I got a lot of problems with you people. I got a lot of problems with wellness programs. So that's so what do I think about wellness programs? I'll give you my sort of 30,000-foot spiel, and then kind of launch into talking about ADA issues, and maybe if there's time, I'll talk a little bit about other stuff. But my basic view of wellness programs that are implemented by employers is, they're certainly extremely well-intentioned. I think that they come often, if not nearly always, from a place of employers who really care about the welfare of their employees. Obviously, there are also concerns about cost, but I take it as an example of what feels to managers who implement these programs as a kind of interest convergence, right? Economizing on costs at the same time that they're helping their employees. But I think they also often push the boundaries, if not exceed the boundaries of what the law is. They push, if not exceed the boundaries of what the law should be, certainly. and are not good health policy, and give employers a power over their workers' private lives that I don't think employers ought to have, that private parties who have such power over people's lives as employers ought not to have. Aside from that, I think they're great. So that will inform my discussion of the legalities. One of the aspects of the ADA issue that is difficult to talk about, that makes this difficult to talk about, is what Chris is about to say, which is that the EEOC has pending regulations. They issued a set of proposed rules implementing the ADA with respect to wellness programs last year. They are proposed rules that received a lot of response. I think they were understood by the EEOC as sort of compromising between a bunch of positions, and like most compromises, they didn't leave many people happy at all on either side. I'm going to be talking to some extent about the proposed rules, but there are final rules that hopefully will be issued soon that Chris is probably the only person in the room who knows what they actually say. So to some extent, and he can't tell the rest of us. So to some extent, this is going to be attacking a target that I don't fully know about yet, but I think the general principles are important principles. So the thing about workplace wellness programs is they can have significant effects on workers with disabling conditions in a couple of different ways, right? So the general way of thinking about it, the sort of general problem is the one that John identified, which is if you have employers who are worried about cost, they can deal with the worry about cost of their employees in a couple of ways. They can work with the employees they have to try to reduce the cost the employees pose, or they can just find less costly employees. And historically, employees with disabilities have been understood, whether rightly or wrongly by employers, as those more costly employees. Wellness programs can be seen as, and were seen even at the time the ADA was adopted, as one significant possible way in which employers could exercise that willingness to exclude employees who are more costly. So a couple of ways in which this can happen, right? A couple of ways in which, whether intentionally or unintentionally, workplace wellness programs can exclude workers with disabilities. There are obviously a couple of different kinds of wellness programs. People talk about them in sort of two big buckets. One bucket is kind of the outcome contingent program, the program that says, look, if you hit a certain target, if you do certain things that achieve certain goals, then you're going to get some kind of benefit from us. The other are the sort of the more participatory programs. For both of those kinds of programs, there can be problems with excluding workers with disabilities because the outcomes may be outcomes that are impossible to achieve for a given worker because of physical limitations imposed by a disability. And I think this is a more general problem that with wellness programs, that they assume a certain ideal social and environmental and physical situation of employees, that they can achieve certain outcomes which may not be possible for every employee. But in the disability context, specifically, there may be something about a disabling medical condition that makes it impossible to lose weight, for example, and that's something that under the ADA would have to be reasonably accommodated. There may be a participatory wellness program that provides incentives for employees to, say, join a gym, and if there's no gym nearby that is accessible, there may have to be an accommodation for that. Now, I would say this is at least as a legal matter something that everybody agrees on. So, I mean, it's a pretty uncontroversial statement of the law. The EEOC has purported to agree with that, even in their proposed rules, which I will otherwise criticize. But this is sort of a general statement of the law that most people agree on. I will say, though, it's important in highlighting some of the problems with wellness programs. That is, the assumption behind a wellness program is that a lot having to do with health is within the employee's control. A disability might be a reason why an individual's health is not, in fact, within the employee's control, but it's not the only one. And I know when we get the papers later today, I know Jessica's going to talk a little bit about this, but you might think more generally that there are other reasons why health might not be in an individual's control fully, that have to do with socioeconomic status, that have to do with environmental factors that an individual can't realistically control. So even though the legal point about accommodation is one that's uncontroversial legally, I think it highlights a problem. The legal point that is highly controversial is the question of how we deal with actually these participatory programs that require individuals to provide certain medical information to their employees in order to participate, and that provide certain incentives to employees to provide medical information to their employers to participate. I may have flipped that earlier. And the question there is a very important one, because historically, one way that employers have found to discriminate against employees with disabling conditions, who they fear, again, as I said, maybe legitimately, maybe not, will be more costly, has been to gather otherwise work-irrelevant information about the medical conditions of their employees and use that information as a basis for making adverse hiring decisions. So when the ADA was passed in 1990, one of the central provisions of the ADA in employment prohibits employers from asking their workers about their medical conditions, right? It prohibits medical examinations and inquiries unless they're job-related and consistent with business necessity. That's the language of the statute. The basic idea is employers shouldn't be able to ask job-irrelevant stuff about their employees' medical history because of concerns about discrimination, and concerns that even if you tried to wall off information within a particular office of an employer, it gets around and an employer might take adverse action that might be very difficult to prove is in fact discrimination, but will in many cases be discrimination. Now, in 1990, when Congress passed the ADA, wellness programs were already a thing. I mean, they weren't a thing like they are today, but they were already a thing. And so there's a specific provision in the ADA that exempts from this rule. Here's the language: voluntary medical examinations, including voluntary medical histories, which are part of an employee health program available to employees at that work site. So the crucial word there obviously is voluntary, right? And the question is, what is voluntary? Obviously, if you are an employer who thinks that wellness programs are really good for your employees, and we heard some of that this morning, then you're going to have a strong reason, fully in good faith, to try to give as much incentive to your employees as possible to participate in these programs. And prior to this administration, the EEOC had not been very clear, but a number of EEOC commissioners, a number of statements coming out of the EEOC had indicated that any significant financial incentive in particular would vitiate voluntariness. And this is obviously something that, for a lot of employers who wanted to do wellness programs, was seen as a problem. In the Affordable Care Act, and even before the Affordable Care Act, in rules governing HIPAA, there were certain numerical thresholds that Congress and that the regulators adopted for determining what was voluntariness in terms of participation in a wellness program, particularly having to do with the cost of, if a monetary incentive was above a certain percentage of the cost of providing health insurance, it would not be voluntary. The ADA doesn't contain anything like that. So this was very much an open issue under the ADA. And one thing that's clear as a matter of law is that regardless of what any other statute allows, the ADA independently imposes limitations on employers. So just because the ACA allows it, it doesn't mean the ADA also allows it. There's a separate analysis that's required. So in this administration, the EEOC began to be aggressive about wellness programs, at least for a while. They brought 3 cases in 2014 challenging wellness programs adopted by employers that imposed quite significant monetary penalties on employees who didn't participate in the thousands of dollars a year kind of category. In one case, at least the allegation was, an individual's health insurance was revoked by an employer for not participating in a wellness program. This set of actions by the EEOC led to a political backlash by the business community. The business community was up in arms. They like wellness programs, and they respond. And a lot of people like wellness programs, including a lot of liberals in Congress, including people like Tom Harkin, who was the principal drafter of the ADA. A lot of folks like wellness programs, but the business community really likes wellness programs, and they responded by putting severe pressure on the White House to itself put severe pressure on the EEOC. And I'm not telling tales out of school here. I mean, you can read about this in the Washington Post. You can read about this sort of in anything that covers Washington. And the EEOC happened after that to issue a set of proposed regulations on wellness programs. These are decisions that were above Chris's pay grade, so I'm not criticizing Chris, but nonetheless, he's the person responsible for drafting these regulations.
And I'm here.
And he's right next to me. So whatever. It seemed very sedate and pleasant this morning, and I don't like that. I'm sorry. It's Passover on Friday, next Friday. Come to my Seder, you'll see I'm being very kind and gentle compared to my family. But in any event, so the EEOC responded by issuing a set of rules that had certain limitations on wellness programs, but also crucially defined voluntariness for the first time under the ADA for these purposes. And the way they defined voluntariness is they said that an employer can impose an incentive of up to 30% of the total cost of employee-only coverage and still have participation be voluntary for an employee. Okay, and it can be a positive or a negative incentive. I think the EEOC is exactly right to recognize that missing out on a benefit of $1,800, which is the average cost of 30% of employee-only coverage in America, is the same thing as being penalized, $1,800 if you're an employee. But 30% of the cost of employee-only coverage was at least the way in the original regulation they defined voluntariness. Now, I think many people would say, particularly for employees who are not making a lot of money, that 30% of the cost of employee-only coverage, an average of $1,800 a year, in some cases more than that, right, because it depends on the particular insurance coverage of the particular employer, that is an incentive that would be very difficult to turn down. One that in ordinary speech we would not think of as something consistent with voluntariness, with a voluntary decision. If you get told, if you don't give me all this health information, employee, I'm going to cut $2,000 from your pay for the year, a lot of us are going to have a really hard time saying no. Now, the word voluntary in the law happens to be, incredibly protean. The word voluntary in general happens to be incredibly protean. Nobody knows exactly what it means, but on an ordinary kind of common sense, ordinary language understanding of voluntary, this does not really fit voluntariness. And the EEOC, in its explanation for why it defined voluntary this way, I think did the best they could, and I think they were really trying to thread a political needle, but it's obvious that they were threading a political needle rather than doing something that made sense of the statute. And here's why. And I love Chris. I mean, Chris is I've been a big fan of Chris's for 20 years, so this is not about Chris. But nonetheless, I don't think the regulation as it was proposed is deeply is consistent with a rational understanding of the law. So the explanation that the EEOC gave was that the ADA had to be harmonized with the Affordable Care Act. The Affordable Care Act for outcome contingent wellness programs, not participatory wellness programs, said that outcome contingent wellness programs would be okay if the financial incentive was no greater than 30% of family coverage if someone's entire family is covered. So notice there's 30% is the same as between both of those, but it's 30% of two very different things for two very different kinds of program. So the idea that what it's doing is really harmonizing with the Affordable Care Act doesn't make a lot of sense. And in any event, the idea that we needed to harmonize the ADA with the ACA.
Again, 30% of what is in the EEOC?
So the EEOC, at least in their proposed regulations, said it's voluntary if the incentive is no greater than 30% of the cost of individual-only coverage. what the Affordable Care Act says is it's allowed if if the incentive is no more than 30% of the cost of either individual or family coverage, right?
Did it make a difference whether the individual or the family was covered?
Yes.
In other words,
Yeah, exactly. But the EOC draws no such distinction. Yeah,
but
or
I'm
didn't.
saying, in other words, for
Oh.
the individual, you could say it's 30% of their coverage, and then for each dependent, it could be 30% of their coverage.
Right.
They're covered separate. In other words, the incentive, in other words,
Yes.
in our incentive program, it's 30% of, since we have more than one
Right.
person covered, it's 30%.
Right, and so that's what's allowable under the Affordable Care Act, but that's distinct from that's different from what the EEOC's rule for the ADA would have allowed, right? So there's already a slippage there, because what you would be doing is actually imposing an incentive that's greater, because you're asking an employee.
No, we're not judging
Okay, well.
Each of the employee and the dependents are judged.
Okay, yes, so I understand. So are you asking for medical information about the employee? If you ask the information to fill out a health status questionnaire, and he doesn't do it.
No, it's not that. It is if they don't hit certain targets.
Yeah. Okay. So this is a right. So when we're talking about this is the other difference, right? So the other difference between the ACA and the ADA proposed rule was the ADA proposed rule was not about these outcome contingent programs. It was so it wasn't about hitting these targets. It was about if you don't give the information. So the point is, there's something that at a very surface level makes it look the same, but it's really a very different inquiry. And so to that extent, it didn't seem to make a lot of sense to me. Now I understand I'm at my time. Oh, I have 5 minutes. Okay, good. I thought I was watching the clock. I should watch John.
I started a tiny bit late.
I should watch John. So let me say one other thing about this. So to some extent, the big fight about the ADA and wellness programs may not be the one that I've just been engaging, right? So that's the one that a lot of people have had in response to the EEOC's proposed regulations. But there's another fight going on, one in which the EEOC actually has, in my view, at least in their proposed regulations, and from the whispers I hear through the hallways of Washington, may in their final regulations be taking a view I think is correct on, which is a much broader question, whether these wellness programs are regulable under the ADA at all. So there is in the original ADA this provision that got added to protect the interest of insurance companies that nobody actually knows what it means. I've thought about writing articles about it for years, and nobody knows exactly what it means. But what it says is it's a safe harbor, and what it says is that the ADA shouldn't be construed to prohibit or restrict, and the relevant provision is here: a person or organization covered by this chapter, including an employer, from establishing, sponsoring, observing, or administering the terms of a bona fide benefit plan that are based on underwriting risks, classifying risks, or administering such risks that are based on or not inconsistent with state law. Or if they're self-insured and therefore covered by ERISA, there's a similar provision as well that again that says a person or organization covered by this chapter is not limited from establishing, sponsoring, observing, or administering the terms of a bona fide benefit plan. So nobody knows exactly what that means. A number of courts, including in the cases that a couple of the cases that the EEOC has brought that actually triggered some of this political response that led to the regulations, a number of courts have said basically so long as a wellness program is attached to a health plan, so long as it's a condition for receiving health insurance, then it becomes a term of a bona fide benefit plan. And if it's a term of a bona fide benefit plan, it just can't be regulated by the ADA. And that's the position a couple of district courts have now taken in the EEOC litigation challenging wellness programs. It's something that the EEOC in its proposed regulation said is wrong, is not the proper interpretation of the ADA. The EEOC gets at least some deference in interpreting the ADA by the courts, although these couple of courts did not give the EEOC that deference. for a variety of reasons that I really don't have time to get into now, but would be happy to talk about, I happen to think that's the way the courts have read this is the wrong interpretation of this safe harbor provision, that in fact they would read this provision as basically reading the medical examination part of the ADA out of the statute in a way that clearly is not what Congress meant to do. And I think the best way to read the statute is, the safe harbor provision is to say, an employer gets to set terms that administer risk, gets to set terms that underwrite risk. So it gets to say, when we're providing you insurance, we can charge more to people in different risk classes because that's how insurance works in America. There's a big critique about how that works, but that's how insurance works. That's what Congress wasn't trying to change. Congress was clearly not saying that you can justify any discrimination you want, employer, if you just say, well, if you have this disability, you're not entitled to our benefit plan, or if you don't do this, you're not entitled to our benefit plan, thereby making it a term of the benefit plan. But in any event, so that's my legal critique. I have many other criticisms, but that's the legal critique, and thank you very much for listening.
Okay, good afternoon. Unfortunately, the timing of this conference and maybe the timing of the issuance of our final regulations makes it unfortunate that I can't tell you what is in the final rules, and we have to talk for the next few minutes about, by reference to the proposed rule and some of the issues that EEOC was grappling with in that proposed rule and why the Commission said it came down the way that it did in the proposed rule and some of the comments that we received in response to that rule. The final rules, and I actually want to mention two rules, because both of them have something to say about wellness programs. And one of them is the ADA that we've been talking about. The other is the Genetic Information Non-Discrimination Act. And how does GINA come into play? Title II of GINA comes into play when an employer wants to do the thing that I think the questioner over here was mentioning, when the employer wants to ask and condition a portion of incentives on family members participating in wellness programs. Family member current health status information, not their genetic information about predispositions to diseases or disorders they may acquire, but actual, do you have diabetes, do you have a particular health condition right now, cancer. That family information, that's family medical history, and it's considered genetic information about the employee. And our GINA regulations currently say that no inducement, we use the term inducement under the GINA rules, it's the same as an incentive, in a wellness program can be conditioned on employees providing their genetic information. So some wellness programs want to ask for spousal current health status information, and that's actually considered genetic information about the employee. As strange as that may sound, even though the conditions aren't hereditary for the employee, such that the employer could assume that the employee is going to develop that condition in the future, that's still considered genetic information about the employee. The answer to the question of why that is so is that Congress said it was so. There's a very specific provision in GINA that talks about blood relatives being family members, but separately says it includes dependents within the meaning of ERISA. And when you look to ERISA, you see that dependents include, so the particular section includes spouses and children and adopted children or children placed for adoption. So I just want to sort of clear that away before we get into a few issues where that I think we grappled with in both of the rules, and where we came down in the proposed rules in ways that, although I was surprised to hear Sam say many people weren't satisfied, I don't think anybody was satisfied, frankly. At the end of the day, everyone had some sort of criticism about some aspect of both of these rules. The ADA proposed rule was issued last April 20th. The GINA final proposed rule was issued on October 30th of last year. The two rules are scheduled to come out actually this month according to our regulatory agenda, so we'll see. We have 15 days left with people needing to take time to file their taxes. But we have these two rules that I think need to be read together when it comes to wellness programs. Now, both of them say fundamentally that wellness programs have to be, both of them govern wellness programs in the sense that they're included in the definition of health or genetic services under GINA. They're health programs within the meaning of the ADA, and they have to be voluntary. It's correct that the definition, the EEOC never really has said, or Congress never said, what does voluntary mean under both ADA and GINA? EEOC has said a couple of things, but not much. In 2000, we said in some sub-regulatory guidance that voluntary means an individual is neither required to participate nor penalized for non-participation. We say virtually the same thing in the GINA or in the GINA regulations that we issued in 2010. Along comes the Affordable Care Act, and it says incentives can be offered in connection with wellness programs, health contingent wellness programs that require that someone either engage in some kind of activity that may be prevented by a health condition or that achieve some sort of health metric. And in those instances, because HIPAA and the Affordable Care Act are concerned with not discriminating against individuals on the basis of a health status, the final Affordable Care Act rules, the tri-agency rules from Department of Labor, HHS, and IRS say that that incentive cannot exceed 30% of the total cost of self-only coverage, where it's just the employee participating, and it can't exceed 30% of the total cost of whatever plan the employee is enrolled in, be that self or family, self plus one, where the spouse and family members are offered an opportunity to participate in the wellness program. So what we do in the ADA, but the rules under the Affordable Care Act are only concerned with discrimination on the basis of health status. And so that has several consequences because there are differences between that and what the ADA and what GINA are concerned with. Both the ADA and GINA are not only concerned with don't discriminate against people based on their disability or their genetic information, but also they both limit the circumstances under which employers, through their wellness programs, the wellness programs are their agents, can get medical information about employees. So unlike, and the consequence of that is this with respect to how we deal with these incentive issues in the ADA. HIPAA, the Affordable Care Act, aren't concerned with what incentive limit applies, if any, where someone is simply asked to complete a health risk assessment or a family member is asked to complete a health risk assessment. As long as everybody is asked to do it, an employer can require everybody to do it and in fact could say you're not going to get health insurance if you don't do it. Those kinds of activities would not violate HIPAA and the Affordable Care Act, nor would imposing a larger than 30% incentive. Our proposed rules say we're going to extend, we have an interest, the EEOC, in regulating access to this information, not just whether the results are used to discriminate on the basis of disability or genetic information, but we have an interest in regulating, because of our laws, the employer's access to that information in the first place. And the consequence of that is that our rules say you can't require someone to participate, you can't condition their getting health care, participating in the employer's health plan on whether they participate in a wellness program and provide medical information in connection with it. And you can't restrict someone's access to a particular plan because that person doesn't provide health information. So for example, what I've heard of called tiered health plans, where you can get into our gold plan if you answer questions on the health risk assessment. You can't get into it, you get the bronze plan if you don't answer the questions. Those would be prohibited under the terms of the proposed rules. Another consequence of the fact that we have greater flexibility, or not flexibility, but greater authority to regulate with respect to acquiring this information in the first place, not just whether it's used in a discriminatory way, is that as I think I said, we extended the 30% limit to participatory only programs. So the 30% limit applies to any wellness program that conditions getting an incentive on either the employer or the employee providing health information, or a family member providing current health status information. Another thing that we did in the GINA regulation, two things that I think are more protective than what the Affordable Care Act rules would do, is that we said that, okay, employers can condition part of an incentive under GINA on the employee's spouse providing current health status information, but they can't condition any part of the incentive on whether information about a child's current health status information is provided. The rationale for that: information about children is more likely the kind of information that could be used to discriminate against the employee on the basis of a condition that the employer thinks the employee may have or may develop. The second thing that we did differently under the GINA rule was to say that with respect to that larger 30% of the cost of whatever plan the person is enrolled in, we're going to apportion those incentives. The tri-agency Affordable Care Act rules don't do this. And we're going to say that a certain amount of the incentive is for the employee's participation in answering the questions, and a certain percentage is for the spouse's participation. And the maximum incentive for the employee's participation is equal to 30% of the cost of self-only coverage, which is the same limit that we've prescribed under the ADA proposed rule. We have some provisions concerning confidentiality. It's critically important, and a lot of the comments that we received about both rules had to do with enhancing confidentiality. One of the things that's done in the ADA proposed rule is that there's already a provision like this in GINA that says employer only gets the information back from the wellness program in aggregate terms that don't reveal particular individuals and their medical information. We've added a similar provision in the proposed rule for under the ADA concerning employers getting aggregate information, only aggregate information from the wellness programs. What about the wellness programs themselves? What about if they disclose information to third parties about individuals? My view would be that under both laws, that practice is currently prohibited. At least the employer would be responsible for any disclosures that the wellness program as its agent is making to third parties that don't fit within any of the confidentiality exceptions in either the ADA or GINA. And none of the disclosures to third parties for the purpose of data mining or collecting information so that they can target people for advertisements certainly would not fit into any of those confidentiality provisions. Another thing that we do in the ADA proposed rule is say GINA already requires that people give prior written knowing and voluntary authorization to participation in a wellness program. Under the ADA rule, we also say, because there is no specific requirement like this, employees have to get a notice that tells them what information is going to be collected, with whom it's going to be shared, for what purposes it's going to be shared, what the limitations are on its disclosure, and what measures will be taken to ensure its confidentiality. We're also concerned in the ADA rule, well, in both the ADA and the GINA proposed rules, that wellness programs really be doing something, that this not just be data mining, collecting the information, never giving individuals feedback on their particular health risks, or not even using the information to design, aggregate information to design specific disease management programs. And so we borrow substantially from the reasonably designed standard under HIPAA and the Affordable Care Act. We say health programs under the ADA and health and genetic services have to be reasonably designed to promote health and prevent disease. They can't place excessive burdens on individuals who are participating in them. They can't be a subterfuge to evade compliance with the ADA or other EEO laws. Some commenters have said this isn't enough, that there should be a higher standard that says that these programs have to be consistent with sound science, or they have to be evidence-based, but the proposed rule at least borrows from the ACA standard, reasonably designed to promote health and prevent disease. We say some things about reasonable accommodation, that reasonable accommodation under the ADA has to be provided to employees both in health contingent programs who can't meet a standard because of a disability. The ACA already requires a reasonable alternative standard, and that people be made aware of the fact that reasonable alternative standards are available that may fulfill the reasonable accommodation obligation under the ADA if, in fact, the employer and the wellness program are advertising and providing the reasonable alternative standard. One gap in terms of reasonable alternative standards, though, is in purely participatory programs where the Affordable Care Act regulations don't say anything about reasonable alternative standards. So, for example, a deaf person who wants to go to a smoking cessation class, it's a purely participatory program and needs a sign language interpreter to engage in that activity, that would be a situation in which reasonable accommodation would have to be provided in order to ensure equal access to benefits and privileges of employment. The last thing that I'll say is exactly the last thing that Sam closed on, which is the ADA safe harbor provision. One of the cases that we have been litigating, EEOC versus Flambeau, is on appeal. Our brief is due on April 26th, so we'll see whether the brief or the final rules come out first, but that brief is due on April 26th. And I wholeheartedly agree with Sam's take on that this is a provision in the ADA. The easiest way I have to explain it is the ADA is a law that says you can't discriminate against people with disabilities. You can't treat them differently because of their disability. Why is the safe harbor a safe harbor? Because the safe harbor says in some situations, exceptional situations, you can justify treating some people with disabilities differently where it's in accordance with actual insurance practices, where it's based on actual or risks, actuarial data, reasonably anticipated risks. So Congress was trying to protect here certain practices of the insurance industry that allowed where extra costs could be tied to a particular condition to charge that individual more, or even in some instances make determination that the person is uninsurable. Notably, a lot of the practices that were protected under the safe harbor in 1990 were practices that have now been made illegal by either HIPAA, the Affordable Care Act, exclusion of individuals with pre-existing conditions, and charging more to particular individuals within a group plan because of their health conditions. So this is an extremely narrow exception that was intended to protect certain insurance practices prevalent at the time. It was not, in the Commission's view, a provision that was intended to shield any wellness program that an employer says has been designed to reduce risks from scrutiny by the EEOC or from regulation. So would certainly agree on that. And this is a big issue because, indeed, if the safe harbor does apply in the way the courts have applied it now, we won't be worrying about the level of incentives for wellness programs and whether they're coercively high. We'll have practices like employers being able to deny health insurance or shift the entire cost to individuals who don't participate.
Thank you. Really quickly, before turning to questions from the audience, I don't know if either of our panelists wanted to take a moment just to respond to some of what they've heard from each other. Happy to go to questions from the audience. Also, I'm getting some questions from online viewers. But Sam, did you want to?
There are online viewers with questions. No, I mean, I have nothing to add to that. I think it was a useful summary of what's going on.
Okay, so folks who just wait for microphones to make their way around while the microphones, there's one there and one over there. I will ask the question, just got emailed. I'll tone it down a tiny bit. Question for Chris, asking how can it be that a requirement to hand over medical or genetic family history type information under penalty of paying thousands of dollars more for health insurance be considered quote unquote voluntary? And isn't this just a means test to exercise civil rights, i.e. you must have the means to afford to say no?
Well, I think this echoes a lot of the comments that we received. We were certainly asked that, or certainly told that you can't have any a type of situation where an incentive or anything more than a de minimis incentive is offered and still have a voluntary program. I understand those comments and questions. I don't know that I have a fully satisfactory answer to the person who asked them. The commission really believed that it was that you could not have a situation, you have two laws 20 years apart, and although the Affordable Care Act certainly didn't repeal the ADA, it certainly does say that incentives are permissible, not just for activity-based programs that don't ask for any kind of medical information, but also for certain health contingent programs that do. And it was, a challenge to try to figure out how can we have, on the one hand, the Affordable Care Act that says this is a permissible employer practice to do this, or permissible insurance plan practice, and on the other hand to say, but it's not a permissible practice under the ADA. And so we looked to, what was the rationale for the 30% rule under the tri-agency regulations and by Congress. And Congress was certainly concerned with the same kinds of things. To a great extent, it wasn't interpreting the term voluntary, but it did say we picked this threshold because we wanted something that would not have the effect of denying a coverage to people based on their health conditions, or that would impose an excessive penalty. And that was, the judgment that Congress made, that this was an appropriate level. We looked to that, and although we didn't agree in all respects, as I said, we extended it to participatory only programs, and we built in some protections around apportioning the incentives under GINA. But we thought that the Commission thought it needed to look to the Affordable Care Act, at least to some extent, for guidance on this point. I know there's a lot of, I know there's disagreement about this, but it does seem an oddity, at least, to say this is permissible under the Affordable Care Act and not permissible under the ADA.
So could I just very briefly on that? I think that is the way the Commission has understood it. I think that's actually the wrong legal framing here. The Affordable Care Act does not say this is a permissible employer practice. The Affordable Care Act says this is a practice that is not prohibited by the Affordable Care Act. The Affordable Care Act also says that the Affordable Care Act does not detract from any of the anti-discrimination provisions that existed before. And one of those provisions was that health information provision has to be voluntary. And so I think you can't really avoid, I think the Commission is trying to harmonize, but it's avoiding the question of whether this is voluntary. And, I think you can't really avoid that question. So I think that's the fundamental disagreement I would have with the Commission here.
Mr. Gabinet.
So, I have a question for Professor Bagenstos about voluntariness. It seems to me it's fair to say that the marginal value of money, and hence the marginal value of an incentive, is going to differ from person to person, even within a given employee income group. If that is the case, and I think it is, how is it possible to make interpersonal comparisons about what is and what is not going to be voluntary? Or if we simply say, as I think we can, that the value of money has a downward slope, the marginal value of money has a downward slope, would not that suggest that what we should really have is a graduated system of incentives rather than an arbitrary 30% of the cost of an individual or of a family membership?
Yeah, so I think that's a terrific question. You know, as I said in the talk, the term voluntary, the concept of voluntariness, right, is a term of incredible difficulty conceptually. And you know, can we make interpersonal comparisons with respect to voluntariness? At some philosophical level, I might agree that we can't, but the law requires us to do that here as well as in many other places. I do think that you're right. One way of slicing this is to think about declining marginal utility of money and say, at the very least, 30% of employee-only coverage for someone who's making, you know, $25,000 a year, or $45,000 or $50,000 a year is very different than 20% of employee-only coverage for someone making a lot more, right? That does seem to impede the choice much more. We still have the question of like what's the degree of pressure on the choice that we're going to say vitiates voluntariness, and that's always the question we have in voluntariness. But what I would submit is that 30% of employee-only coverage is not something that tracks ordinary understandings of voluntariness in a very large swath of cases.
So you've talked a lot about disability discrimination, and I'm wondering if there's any concern about women with children, or especially single mothers, who simply are not going to have time to go to the gym or do meditation programs or whatever. Has that been a concern or addressed at all?
I mean, I'd be interested to hear what Chris.
I mean, it's not been addressed in any detail in the regulations that we've proposed, simply because they're not regulations under Title VII. We have said, and Gina already says, and we've added a specific provision to the ADA proposed rule on wellness programs that says, you know, that compliance with this rule, including the incentive limits, does not guarantee, you know, does not mean that an employer has complied with other laws that other EEO laws, including Title VII. And I think a case like that would be, you know, if there was actually some evidence that the plan was intentionally adopted, obviously, to discriminate against women, you might have some kind of intentional disparate treatment claim. More likely, that's going to look like a disparate impact claim under Title VII, and I don't know the extent to which the impact would be in any way vitiated by the availability of reasonable alternative standards for health contingent programs. So these are questions that are still out there. I haven't, not aware of particular charges or cases or, frankly, any regulatory language beyond what I've told you in which we've specifically addressed it.
So I have a question. How did this 30% provision get into the ACA? Do you know anything about the legislative history? Was this being pushed by the public health people, by employers? I mean, it seems so utterly indefensible based on some of the comments that we've heard.
I don't know. I know the little that I've told you about why, you know, Congress said it sort of settled on this mark of the 30%. There's also, you know, built into the Affordable Care Act, there are affordability standards so that whatever incentive you provide, that someone who refuses that incentive doesn't get the incentive or gets penalized, the cost of their health insurance can't be rendered unaffordable. And there's a particular affordability standard of, I think, 9.5% of household income or something under some IRS regulations. So the number, the 30%, is also bounded by this notion of affordability, that employers aren't going to be providing up to 30% of the incentive if the consequence of refusing to accept that much would be that an employee's insurance would become unaffordable.
We'll actually come to that point in the next session, spoiler. I had a question for Sam, and I'm not sure I fully understood what you said about the concept of voluntariness, which I agree is complex, but I think we will agree that what is uncontroversial is that a program that is coercive is not voluntary, right? And so the concept of coercion is a little easier. Typically, you would say the threat of a negative consequence makes something coercive. But if I understood you correctly, then you said you question whether the program is voluntary that either confers a financial disadvantage on you, which would be the threat of a negative consequence, but equally if it's missing out on a positive incentive. Is that correct? Did I understand that?
Yeah, I mean, so this is just the baseline problem that you always have when dealing with coercion. So I actually don't think coercion is necessarily any better. So this is as compared to the pre-existing baseline. So the baseline set by the employer, but since the employer can very easily manipulate the baseline, I think this is why the EOC takes the position that positive and negative are equivalent in this context. The employer could say, look, here's what insurance costs, and you get a $2,000 benefit if you participate, or they could say insurance costs $2,000 less, but you get a $2,000 penalty if you participate, right? And so in that context, thinking about positive and negative as different doesn't make a lot of sense. I think.
Yeah, I think I would dispute that. So let's just say somebody gives you a benefit of just $1, right? Would you therefore say that doesn't make it voluntary? It seems to me to do more with the magnitude of the advantage or disadvantage. If you've both of you have paid $100 a month before somebody thought of some great wellness program. Now, Sam, you are offered $1 if you do a health risk assessment. Are you then saying because
no, I think we're agreeing.
Because Chris doesn't get it.
Because I think we both agree that it's the magnitude and not the positive or negative. So I don't think we disagree. About
Sorry, we agree, because I know that you don't like that.
We have
I know, I hate agreeing.
We have time for two more quick questions. I know we have one here in the front and then one in the back.
So piggybacking off of Sharona's question, I was curious if there's been any discussion of the need for some kind of regulations related to pregnancy-related information, because that's something that can be collected in conjunction with wellness programs, and there was a little flurry of controversy when one company said, hey, if we have your wellness data, we can give you an estimate of the number of your employees who are trying to get pregnant. And that's information that wouldn't necessarily fall underneath the GINA or the ADA.
Right.
And so, but that's definitely health-related information and something that most folks would consider private. So is there any move to regulate in that sphere?
We haven't proposed anything at this point. Those are not right. They're not questions about disability or genetic information. They're not questions that specifically are prohibited under Title VII, although if an employer asks them in the context, for example, of a job interview, if we know that, we're going to assume that the employer asked that because it thought the information was relevant, and so we're very closely going to look at that if the person isn't hired. But generally, the question is that Title VII doesn't have these same provisions like the ADA and GINA that actually close off access to information. One of the intriguing points that someone made this morning, where you might see this come up under Title VII perhaps, is where someone claims, you're asking me about whether I'm going to become pregnant. You're not asking men about their sexual habits or what they're going to be doing over the course of the next year, and that's a form of sex discrimination, plain and simple.
In the back.
Do these wellness programs exist under Medicare and Medicaid, and if not, is that something that's going to happen? As I'm getting older.
I don't. They do. They do exist. Okay. And by the way.
And they also exist for retirees who are cross-covered under the other part.
And by the way, our regulations both talk about wellness programs in the context of group health plans or that are part of a group health plan. One of the questions we asked was, ought we to talk about wellness programs that aren't part of group health plans in a final rule, and what, if we did that, what should it look like?
Well, please join me in.
Is there any provision on this on the, I apologize, on the private exchanges? Because in other words, under the Cadillac tax provision, 60% of people will be taxed that way. So it's going to end up with private exchanges, which isn't good stuff.
Okay, quick time for one last question, and then we're going to have our break. So
just a very practical question. What is the scope of the problem with regard to how many wellness programs really are scams that were set up not to reasonably promote the health of their employees, but are really there to identify either costly employees to be later terminated or for data mining?
I don't think I don't know for sure how many there are like that. I I have heard of situations, not those particular examples, but where employers were characterizing periodic medical examinations, required physicals every year of their employees as quote wellness programs, and people were getting terminated or disciplined if they didn't go to the physical. And under our regulations, those types of examinations without any specific kind of evidence that a particular employee is having a work-related problem due to a medical condition, generally, except in some narrow kinds of public safety jobs, are prohibited. So I have heard of situations in which, under the guise of a wellness program or being called a wellness program, employees were subjecting people to yearly physicals that we would say are not permissible.
Ready, we're going to pause there. Please join me again in thanking our panelists. We're going to take a 15-minute break before our final panel, and then we'll have an opportunity for all of our panelists to give some final thoughts. So we'll reconvene in 15 minutes. Thank you very much.